So Olivier, let's go ahead and get started. Want to just say, number one, thank you for everybody logging in today. We're going to talk about the subject we're going to talk about is going to be the lender title insurance and what we need to know to protect our investment. Today, my guest is Olivier Labarre from Zak, Finlay, and Wright. Olivier, thanks for coming on today and sharing some time.
You're welcome, Brock. Thank you for the opportunity.
Yeah. So in just a moment, I'm going to give you an opportunity to introduce yourself and let everybody know a little about your background. Before we get to that, though, just want to let everybody know, for those that were not able to make the webinar today or want to go back to listen to the webinar, we're going to go ahead and post the webinar on our YouTube site, the TaliMar Financial YouTube site. For those that have not gone on that YouTube site, we post a ton of great content about investing in trust deeds, mortgage funds, and just the private lending industry in general. And these types of interviews would be posted on that YouTube site. Also want to let everybody know, these types of webinars are for educational purposes only. Anything we talk about today shouldn't be considered as absolute fact, and highly recommend that you talk to an attorney before making any decisions regarding any investments that you make. So as I mentioned, this is part of a series of webinars that I've been hosting. Typically, I try to host a webinar about once a month, bring in professionals from the industry that either I have worked with directly or I know that work within the private lending industry. And that is one of the reasons why I brought Olivier in today. Many of you know Robert Finlay. He's been a guest on a number of webinars that we've hosted. But when I talked about the need to talk about title insurance, especially lender title insurance, he highly recommended that I bring in Olivier today. So Olivier, with that, please give a quick introduction about yourself and let everybody know about your background.
Sure. Thanks, Brock. So I'm a real estate litigation attorney. I've been in practice for about 15 years. As we alluded to at the beginning, the first 5 years of that was spent at a law firm where I was litigating claims for title insurance companies representing their insureds. And about 10 years ago, I switched over to Wright, Finlay, and Zak, but I've continued handling a wide range of title insurance and title-related issues. We'll talk about this, I'm sure, a little bit later on, but there are a lot of title issues that are not covered by title insurance that still pose problems for lenders, for which they still need to hire attorneys and deal with them. Wright, Finlay, and Zak has been around for, I think, since 1992. We have a presence pretty much on the entire West Coast. And we also handle a wide range of lender-related issues. So obviously, default servicing litigation. We also have a mortgage compliance department. As everyone knows, lending is a highly regulated industry. We have a couple great attorneys on the compliance side. And we also have a transactional department that prepares leases, contracts, purchase sale agreements, all sorts of things like that. So that's a little bit about me and my background.
I appreciate you sharing that. I feel like the lender title insurance is definitely a topic or subject that is probably the least known or I have a least understanding of within the lending industry. It's kind of a very vague belief or understanding of what I have for it. So thanks for coming on. And I also feel like it's one of those things that you don't think about until you need it.
Right.
So, so real quick, before we start with the Q&A, I went ahead and if you have any questions, we're going to talk about a wide variety of topics, and some of the things that we may talk about, you may want to ask questions about or understand better, or may have some comments about. Below is a Q&A button. Please use it. I always like to have these webinars as kind of a back and forth session. It isn't just Olivier and I just asking questions and responding to questions, but love to get your input and have your questions. So feel free to use the Q&A button below. And as those questions come in, I'll incorporate those into our discussion. So with that, let's get started. So first thing let's talk about is, how is a title policy different from other insurance policies? What is title insurance?
Yeah, so in a nutshell, a title insurance policy under the law is considered a contract of indemnity, which means there's no obligation on the title insurance company to issue any sort of loss payment unless and until there's been an actual loss incurred by the insured. It's a little bit different than other insurance, for example, homeowners insurance, right? You get some damage or there's a problem with the house, and then you file the claim, and then you expect the title insurance company to issue a payment. With title insurance policies, that's the last option, the last resort that the title insurance company is going to go to, because the way it's structured is that it gives the title insurance company the opportunity and the right to resolve a title issue through a number of different ways before actually cutting a check to its insured. And typically that's going to be either defending a lawsuit that was filed concerning a title issue or even prosecuting a lawsuit on behalf of the insured. And when you think about it, a lot of these policies, particularly here in California, we're looking at probably at minimum $500,000 for a residential loan policy. So that's a lot of money. So if the title insurance company can spend a fraction of that, even $100,000, $200,000, hiring an attorney to correct this issue or this problem or litigate it through the courts, they have the right to exercise that option. That's typically what you're going to find.
Okay. And so, and again, very basic terms. You've got the lender in a transaction, you've got the lender policy and you've got the owner policy, two very separate policies.
Yes.
Okay.
Yes, that's correct. So obviously as a lender, you're going to be focusing on the lender policy, which ensures the priority of your lien based on the terms and conditions. The owner policy is going to be very different. And they differ significantly in terms of the products that are offered by the title insurance company. They're going to have additional protections on there that you won't find in a lender policy. So First American, for example, I think it was called the Eagle policy, that protected against fraud and forgery and things like that after the date of the policy, things like that you're just not going to find in a lender policy.
Okay, interesting. So typically in a lender policy, what is covered? What are we getting insured for?
So in general terms, it ensures the validity, well, ensures the priority of the lien as of the date that it was recorded, which is also going to be the date of the policy. Some typical, I guess, issues that might come up for lenders are going to be things like.
Stop for a second. When we talk priority, when we say priority, what is your position as a lender? So first, second, third position, obviously.
Correct.
As a lender, you want to be first position. That's you are in the priority #1 position for any repayment of that loan or payoff of that loan.
Correct. And obviously that's important. If you're making a first position or even second position or whatever loan, you want to make sure that the title insurance policy you're getting is insuring you to be in that position, right? That's one of the big reasons to get a title insurance policy. Lien priority disputes are one issue that come up. For example, you make a loan to a borrower, you think you're in first position or second position, then you find out you're not for whatever reason. Prior loan was not paid, it was missed, whatever the circumstances are. That's a big thing. There are a host of other, what I'd call kind of typical title issues that come up for lenders over and over. Some of the smaller ones would be incorrect legal description, right? You've got a deed of trust or a mortgage that references a property. Maybe the legal description is incorrect. Maybe it was left off entirely. So then there's a question as to whether that lien is enforceable. Title insurance covers that. You've got vesting issues. For example, you've got two people on title, but your borrower is only one of those two folks. And the borrower signed the note, he signed the deed of trust, but the other person didn't sign the deed of trust. Well, technically, that deed of trust is only enforceable against that borrower's 50% interest in the property. So as long as you've got a title insurance policy that ensures that your borrower's the 100% vested owner of the property, you're going to have coverage for that. So your lien is going to be enforceable against it. It's not necessarily going to be enforceable, but you're insured to have a lien that's enforceable against the entire 100% interest in the properties. The title company's either got to pay you out or, more commonly, as I mentioned, file a lawsuit to try and validate that lien against the other person's interest in the property.
Okay.
Other things that come up, mechanics liens, and then lack of access, encroachment issues. So lack of access, meaning the property's landlocked. Encroachment issues, there's the house that's on the property that's encroaching onto another lot, or there's another property that's encroaching onto the lender's property.
If you were to say like the top 3 issues that you see pop up What would they be?
Probably incorrect legal description.
Okay.
Um,
And how does that pop
uh,
up though? Give me an example of like when does that
so
become an issue? Is there during usually like litigation, there's something wrong with a note and all of a sudden
yeah, I
you find
mean,
out?
yeah. So typically as a lender, you're probably not going to realize there's any title issues or title problems, particularly when it comes to the legal description or the formalities of the deed of trust or the mortgage, unless and until the loan defaults and you have
Yeah.
to foreclose. And typically, that's going to be picked up by your foreclosure trustee on a TSG.
Mm-hmm.
They'll still tell you, hey, we got a problem. There's no legal description attached to this deed of trust. Or we picked up a second person on title who didn't sign the deed of trust. Because as a lender, generally speaking, as long as the loan is current and eventually getting paid off, there's really no way for you to know unless someone has told you or you've received some type of communication. One of the big issues that we've been dealing with for several years now is actually an issue that's not covered by title insurance, and that is fraud and forgery, post-origination fraud and forgery. So, forged reconveyances or release of a
Yeah.
lender's lien, forged assignments, things like that. Occasionally there'll be fraud and forgery and how the borrower acquired title. So you make a loan to a borrower, everything seems on the up and up. You get your title policy, and then all of a sudden a third party comes out and says, "Hey, I was defrauded," or that deed into that borrower is forged. So I would say fraud and forgery probably the big ones.
Yeah, that's been something that's been discussed, especially at the California Mortgage Association events, the CMA events. Is the fraud and forgery has been a huge issue. We see it where
Yeah,
we get a borrower that communicate or contacts us. They may own a property free and clear, and they want to do a large cash out. It's almost like a red
yeah,
flag right there, and we've
yeah,
been able to catch those type of fraud issues early.
yeah. That and if your borrower acquired title at a foreclosure sale, there are a lot of folks out there that are monitoring foreclosure sales
Okay.
or properties that have been in foreclosure for a while, and then they just record bogus trustees deeds upon sale to make it look like the property foreclosed when in reality it hasn't. So that's another area.
And that title policy, just to confirm, is going to cover that you are covered on the policy for that.
It's it 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 depends. If
Okay.
so a title insurance policy is going so a title insurance policy works retroactively, it doesn't work prospectively. Okay,
Okay.
so a title insurance policy will cover anything, generally speaking, that occurred prior to the date of the policy, as long as it's not excluded or it's not an exception. There'll be
Okay.
coverage for that. Title insurance policies do not cover things that happen prospectively from the date of the policy onward. So for instance, if a lender makes a loan to a borrower and then someone comes out and says, "Hey, that borrower never had title. That borrower forged a deed or defrauded me into conveying him the property," that would be covered because that's a fraud or forgery that arose prior to the date
Okay.
of the policy. On the other hand, if someone comes in and records a forged reconveyance of your lien as a lender, that's not going to be covered by a title insurance policy because that's something that arose after
Interesting.
the
Okay.
date of the policy. So
Okay.
it's still a title issue. It's still a problem for a lender, but there's not going to be any title insurance coverage for them.
So it's up to the lender then to resolve that issue on their own.
That's correct.
Okay. Okay. So we talked the kind of the top three things, the issues that we had: forged documents, assignments. You actually mentioned too. I know that in the trustee world, I know there's been some big cases of forged assignments, or we call
Yeah.
over assigned. They kept assigning the loan out multiple
Right.
multiple times. Has been an issue. Um, so title issue comes up. Is it up to the title company to provide the defense now for the lender to protect their loan?
Yeah. So another aspect of a title insurance policy, not only does it provide coverage for the priority of your lien and the things reflected in the policy, but it also provides a defense to the lenders in the event that they're sued for a covered matter, and that can be a very important feature of a title policy, because as we all know, having to hire an attorney and litigate a case can be expensive. So if a lender's sued for a title insurance or a title issue that falls under the provisions of the policy, the title company is under an obligation to provide a defense. And typically what they do is they will retain counsel that they work with. They'll appoint an attorney who will then represent the lender in that litigation.
And do you, when that occurs, do you have as the lender, do you have the choice? Can you go select your own
within reason? Under the policy, the insured has a right to object as long as it's reasonable. So typically the attorneys that are hired by the title insurance companies are generally very good attorneys at handling the title issues themselves. And they also have negotiated rates with the title insurance company. That's why they choose them. But the problem an insurer is going to run into is if they want to use counsel of their choice, the title insurance company is probably going to say, that's okay, that's fine, as long as they have the experience in this area. But we're only paying them X amount of dollars per hour, right? Then you get into a dispute over the rate of the attorney. So then, and we have a couple clients here who we've submitted title claims for, who like us, who've used us in the past. And those clients say, we want you on this case. And so we work out a deal with them and with the insurance company where the insurance company pays us X amount of dollars, and then the client will pay the difference. So that's always an option.
How often, when there is a claim, how often is there a resolution that goes in favor with in favor for the lender? I mean, is it a common? Is it not? I mean, is it all over the board?
I think it depends on what your definition of a resolution in favor of the lender is, because title insurance companies don't have the same incentives as lenders when it comes to dealing with loans, particularly defaulted loans that are in foreclosure. As a lender, right, your objective is this loan's in default, it's not performing. I got to foreclose as quickly as possible so that I can deal with this, so that I can either sell the property in REO to recoup. Or, sometimes if it's a second position lien, there's a first position lien you got to deal with. You can't really deal with it until you foreclose. So from the lender's perspective, the incentive is really to kind of move forward quickly and get things done. Yeah. The title insurance company, on the other hand, their only duty and obligation is to resolve the title issue. That's it. So they're not concerned, and they don't have any obligation to be concerned with doing things in any kind of expedited manner. To the extent that it might benefit you from a financial perspective. So there's a little bit of tension between the lender and the title insurance company. But I would say most often the matters do resolve in favor of the lender. It's just generally going to take some time because, once again, the title insurance company, if they're filing a lawsuit or they're defending a lawsuit, they're going to defend or they're going to prosecute the lawsuit. Okay. So that said, there are things that can be done in the context of a title insurance issue or lawsuit that can kind of speed things up. For example, you could look at foreclosing while the lawsuit is pending. You can look at retaining private counsel and working as, associating into the lawsuit along with the attorneys for the title insurance company, who can maybe focus on some of the more lender-centric issues and push those forward while the title insurance attorneys are kind of handling the defense or the prosecution of the other things.
Okay. One of the things I forgot to mention, we do a lot of loans where there's either some kind of construction component to it. We either do fix and flip loans, or we're doing what now is really popular, these ADUs, accessory dwelling units, where borrowers buying a property, usually a single family home, on the property, rehabbing it, and then building maybe 3, 4, 5 units in the back. And the big question is mechanics liens. Can you kind of highlight or high level talk about issues with mechanics liens as it relates to title and what you've seen in the past?
Sure. So as we all know, mechanics liens are a little bit unusual because most liens, the priority of that lien will relate back to the date that the lien was recorded. That's why it's important to record those. Mechanics liens in California and a lot of other states operate a little bit differently. They relate back to the date that work started at the property, the date that the contractor actually pitched a shovel into the dirt, or however you want to describe it. So there are some issues that can arise with that as a lender. Typically, those issues are handled at the inception of the loan. If you're making a construction loan, for example, there's a lot of and the title company will generally is generally the one that is going to be looking into all this, because to the extent that the title insurance company is going to be issuing a lender a policy ensuring the priority of their lien over all other liens, including mechanics liens, they need to assure themselves that work hasn't started on the project yet, right? So the title insurance company is going to have all sorts of agreements and indemnity agreements. They're going to solicit warranties and representations from the owner, from contractors, things like that, to protect themselves, because obviously they don't want to issue a title insurance policy insuring a lien over all other liens, and then come to find out there's a mechanics lien that records at some point in the future claiming work started before the date of that loan. That said, there are various endorsements that you can get. I think it's like 32 series endorsements that and those are more relevant for lenders that are coming in, I think, midstream refinancing a construction loan. Okay. And they provide coverage for any advances that were made prior to when the loan was originated. Mm-hmm. So you get that retroactive coverage. But yeah, mechanics liens are an issue, something you have to be careful about. And you just have to make sure that you understand exactly when work started at a project before you make your loan.
Okay. Thanks for that insight. Now, next question. What doesn't it cover? So like if I have an issue and I'm going to go talk to my title company and they're going to just say, hey, Brock, this is not covered under our policy. What am I not going to them with? And I imagine if my borrower goes into default, doesn't make a payment on the loan, that is not their problem.
That's correct. So a title insurance, I think it's important to just note that a title insurance policy only provides coverage for title issues. Yeah. So anything having to do with the loan itself, there's not going to be any coverage for. So for example, if the loan goes into default and you start foreclosure and then you get a lawsuit from a borrower asserting violations of foreclosure statutes or laws, or you get a lawsuit alleging fraud, I was defrauded into obtaining this loan. Those kinds of things are never going to be covered by a title insurance policy. That said, there are a lot of title issues that lenders have to deal with and face that are also just not going to be covered under a title insurance policy. So an example is, for example, fraud or forgery that arises after the date of the policy. Generally, anything that happens after the date of the policy is not going to be covered.
And that's a good point. Besides that, I'm glad you bring that up, because that's one thing I walked away from that I didn't think through. Is you're right. Yeah. So if someone illegally signs or records a quit claim deed, brings it out to somebody, sells it to somebody else, that's not covered.
Correct. Yeah. That's not going to be covered in a title insurance policy. Another big one for lenders that we're seeing is PACE liens, right? I know PACE liens are, for those that aren't familiar here in California, those are energy efficient liens. We call them PACE liens. Those liens have super priority over any of the liens on the property. So, you make a loan, borrower goes out and gets some energy efficient improvements, finances that through a PACE lien. That PACE lien is actually treated as almost a tax lien against the property, and it has super priority.
It is the worst thing ever invented for lenders. It is truly the worst thing.
Yeah. It's very frustrating for a lender.
Yeah, I've had to deal with it on two situations, and when you find out you have those PACE liens in front of you in priority position, it is frustrating. There's nothing as a lender you can do.
No, I mean, the only thing you can do is you could contractually agree with your borrower that if they go out and they get a PACE lien without your prior written approval or consent, that's a material default under the loan and the deed of trust and gives you the right to call it due immediately. Yeah. But
it's still there.
It's still there. The lender still has to deal with it. Yeah.
Yeah, I agree with you. Thanks for bringing that up. That's a good point. So what other items aren't covered? I know we talked about like eminent domain issues, not covered.
So right, eminent domain is not going to be covered. Property taxes, probably the big one for everyone to be familiar with is what we call no loss issues. So like we talked about at the beginning, title insurance policy only kicks in when there's been some type of appreciable harm or loss to the insured or an imminent threat of appreciable harm or loss. So let me give you an example. For instance, an old deed of trust on title, right? You're making a loan to a borrower, or let's say you've made a loan, the loan's in default, you're going to foreclose, and your foreclosure trustee sends you back a TSG and says, we got bad news. There's an unreleased deed of trust from 25 years ago in the chain of title. It's
and
just,
that's
there's
a
no
common
reconveyance.
problem. Olivier, I'll
It's
tell you,
very
that's a
common.
common problem
It's
on a
very common.
closing. I've seen it.
Yeah, it's a very common issue. So as a lender, then you submit your title claim and you say, I've got this unreleased lien on title. Well, the problem is that lien is not in default, or at least there's no notice of default. There's no foreclosure proceedings. It's from so long ago that and it's pretty clear from the chain of title probably that loan was paid off at some point in some transaction many, many, many years ago. And what title insurance companies have done is just kind of removed it as an exception on their policy, and they've just done that time and time again.
And
So under those circumstances,
never actually removed it from title. They just removed it from their policy, the exception.
Correct. That's correct. They don't remove it. It doesn't get removed from title. It just doesn't show as an exception on your particular title insurance policy. So under those circumstances, a title insurance company is very likely to send you a letter saying, thank you for your claim. We acknowledge receipt. However, there's been no loss. There's been no harm to the lender. Please proceed as normal. So in other words, continue with your foreclosure, continue with your normal servicing. In the event this becomes a problem down the road, come back and see us and we'll deal with it.
Wow. Yeah. So I'll tell you from a private lender perspective, I probably see this a couple times a year where we're closing on a property, we're funding a loan, and some either old hard money loan that was done 30 years ago isn't removed. And then you're racing around trying to find out, who that beneficiary is and see if you can't get anything signed. Most likely they've passed away, or there's something
exactly.
You're never going to be able to find them.
So I'll just add one more thing, since our audience is mostly private lenders. I've been seeing lately a lot of specific exceptions on title insurance policies for circumstances where the borrower acquired title through a foreclosure sale. And the exception will generally read something along the lines of, accepting any coverage for any irregularities arising out of the foreclosure sale. So it's just a kind of a red flag. Yeah, pretty big. So basically what that means, if you're making a loan to a borrower who acquired title through a foreclosure sale, and someone comes back and challenges that foreclosure sale, either the borrower under the loan or maybe someone else, the title insurance company can fall back on that and basically say, sorry, there's no coverage for that. And so that's a new one that I'm starting to see.
Oh, interesting. Okay. I gotta tell my team about that, my closing team on that one. So can you quickly walk us through kind of the basics of how a title insurance policy is structured? What are we looking at? What should we, when we're reviewing a prelim title policy, what we should be looking for?
Yeah, so the first few pages of the policy are going to be the insuring provisions and then the terms and conditions, along with the exclusions, right? So the exclusions are things that are uniform across the policies. Those are things that are excluded from coverage. The next important document, the two most important documents for a lender to be focused on, in my opinion, are Schedule A, which tells you the property information, the vesting information. Make sure that Schedule A shows the vesting in your borrower in the manner in which the borrower is claiming it should be held. And then Schedule B is all of your exceptions. So these are things similar to the exclusions. These are things that there might otherwise be coverage for under the insuring provisions, but that have been specifically accepted out. So this is where you would expect, if you're making a second or third position loan, you would expect to find an exception for the first loan on there and the first deed of trust and the recording information. You're going to find exceptions for property taxes, things like that. And these days, that's where you're going to find exceptions for things like PACE liens. I've seen they're starting to be expressly accepted, even though they're subject to some of the exclusions anyway. You're also going to be finding property tax information there, the foreclosure irregularities. So I think Schedule A, as a lender, you really want to confirm that your borrower is the one who's entitled. You want to make sure there's no reference to anyone else there. it should provide the legal description, although that's more of the responsibility of the title insurance company. And Schedule B is really what you want to spend your time looking at. Make sure you understand what's on title, because those are things that your loan is going to be subject to once it records. So if there's anything out of the ordinary there, it's worth bringing up to the title insurance company and the borrower and having that conversation before you actually originate.
Okay, good insight. A question came up. Should a private lender get an ALTA or CLTA policy? And
the coverages are under those are by and far very similar and virtually the same. Yeah, so I don't know that there's any very material differences between an ALTA and a CLTA. I do know that the policies have recently changed in the last, I think, couple of years. They have a new policy out. So I'm actually going to be putting together a separate presentation on that, just going through the different policies. But for purposes of a private lender, it doesn't make a difference.
Okay. So yeah, definitely share that information. I can send that out as well when you put that together. Okay. So walk me through, we have an insurance claim, or I have a potential insurance claim. We talked about this yesterday. What are the steps that we need to take as a lender to file a claim?
So a claim has to be in writing. Typically, it's done by a letter. You just put a letter together. You mail it out. A lot of the title insurance companies will have email intake boxes, so we always recommend you email it and mail it. And in the letter itself, you want to point out what the title issue is, explain it to the title insurance company, and you want to provide them at a minimum with a copy of the title insurance policy, as well as any other maybe relevant documents. So for example, if the lender was sued by someone asserting a title issue or title claim, you want to provide them a copy of that complaint, and you want to provide any evidence of assignment as well. So title insurance policies are, especially loan policies, are issued in the name of the originating lender or its successors and assigned. Okay. So if you're not the originating lender, you want to make sure you're giving them some type of evidence, because that's the first question they're going to ask if they see a different lender. So you want to get ahead of that and just provide that. And typically that could just be as simple as a recorded assignment of the deed of trust. If you don't have that, you can send a redacted, purchase and sale agreement, whatever documentation you have, and obviously quick, redact out all the other.
Yeah, real quick, an assignment simply is a document that's recorded that transfers the ownership of that loan, the beneficiary of that loan, from lender A to lender B, and that's a recorded document. It's called an assignment. So if you're investing in trust deeds, what we had done in the past is TaliMar Financial would record a loan in our name, and then would assign, before we launched a mortgage fund, would assign that loan to our various different investors in the loan. So that's what an assignment is.
Yeah.
So keep going. So your filings.
Yeah. So yeah, and then you submit that to the title insurance company. You don't need an attorney to submit a title claim. We always recommend that you get your counsel involved, because submitting the title claim is really the first step in the process of ensuring that there's coverage for the claim. Yeah. So when I submit my title claim letters, I go through the insurance provisions, I cite them to the title insurance company, and I argue why, the facts of this particular matter warrant that there's coverage here. I try to get ahead of any exceptions or exclusions that might apply. And then that gets out the door, and then you're moving the ships out into the battlefield, to speak.
You mentioned yesterday, go ahead and submit information or connect with the title company, even if if you perceive an issue. It may not be an issue right now, but even if you anticipate an issue, go ahead and reach out.
Yeah, absolutely. So I think if there's one takeaway for everyone to hear today, it would be to really understand the duty to cooperate, the duty to provide timely notice, and the prejudice clause in the title insurance policy, right? Every title insurance policy has a prejudice clause, which allows the insurance company to reduce the amount of the coverage in the amount of the prejudice that a delay in notifying the title insurance company has caused. So I'll give you a couple examples, and these are real world examples that I was personally involved in that we litigated. So in one particular instance, a lender was moving forward with foreclosure loan, was in default. There's an old senior lien that filed a notice of default. For whatever reason, the lender just dropped the ball, didn't appreciate that this was a senior lien, assumed that it was a junior lien that was going to foreclosure, didn't do anything. So that lien actually went ahead and foreclosed, wiped out the lender's lien. And the lender didn't really realize it until maybe like a year later. So by that point, not only had the foreclosure sale happened, but the property had been sold to like 2 or 3 different new owners, right? So then title claim.
And they weren't even aware of this. Oh wow. Okay.
They weren't aware of it. I think the loan was current for a while, and then it went into default. So the title claim gets submitted, and the title company says, "Hey, look, this was a $100,000 lien. Worst case scenario, we could have paid $100,000 a year ago when you told us about it, and we could have paid off this lien. Not only that, but we could have also litigated. We could have done a whole because there were issues with that senior lien and whether it was enforceable or not. But by the time that the claim was submitted, it was too late to really do anything. The property already sold to bona fide purchasers. Generally speaking, you can't go after a bona fide purchaser. So in that circumstance, we had a loan that was about $500,000-$600,000. And, I think at the end of the day, the insured got a check for $100,000 for something like that. So, that was like a $400,000 or $500,000 loss just because the lender dropped the ball there. So I had another case that was much more complicated, much higher loan. It was a $1.5 million loan. And there were a lot of issues with the property. The borrower had actually separated out these 2 lots and conveyed one separately without disclosing it to the title insurance company. And there was a house right in the middle of these 2 lots. And then the borrower had kind of sent these letters off to the lenders and their bankruptcy counsel because the borrower had filed bankruptcy. Long story short, for whatever reason, the lender didn't submit a title claim until we got involved because the lender got sued on something else. And then we were kind of looking through the file and we said, oh my gosh, there's this issue. So we submit the title claim. And one of the big issues in that case is whether the statute of limitations barred the efforts of the title company to go ahead and reform the deed of trust and impose the lien on both of these lots. And that was a real question. There was a lot of exposure there. So that case ended up settling, and it was a decent result, not a great result, but it was a decent result for the lender. But at the end of the day, the delay in notifying the title insurance company could have resulted in a complete loss of coverage on that. And that was a $1.5 million loan. By the time we were dealing with this, the balance was 1.7, 1.8, something like that. It had been default for many years. There's a lot of interest, things like that. So, I always encourage lenders, go ahead and submit a title claim, and just have your antennas up. If there's anything concerning title, whether whether you think it's insignificant or not, whether you think the title insurance company is going to do anything about it, even if you're anticipating that you're going to get a no loss letter, I say just go ahead and submit the claim, because what you're doing is not expecting that issue is going to get fixed or resolved, but you're actually documenting the file, so to speak, and you're taking away the title insurance company's ability down the road, if that does become a problem, to come back and say, well, you knew about this a year ago or 2 years ago. You didn't do anything about it. So you're basically just protecting yourself. You're protecting your coverage.
Yeah. Good input. Good insight. All right. You kind of alluded to this before. Do you need an attorney to file a claim? Is it a good idea?
No, you don't. I mean, I would probably recommend that if you've got a title issue or title problem, you get your attorney involved to get some legal advice on it. But it's not necessary to file the actual claim.
Okay. So I feel like, when I get in if I've been in an accident with a general insurance company, I never get responses back very quickly.
Yeah.
When you submit a claim into a title company, what's the expectation? What am I going to get respond? Are they going to just go dark on me? That's the first thing they do is just don't respond.
No. So what's going to happen is you're going to get an immediate response, probably within minutes. It's going to be an automated thank you for your, especially if you submit it via email, you're going to get an automated response saying, oh, We acknowledge in receipt. Thank you. We'll be in touch with you. And then you can expect a response about roughly every 30 days. They have an obligation to reach out. And while we're talking about that, I think it's also important for lenders to understand that as you're going through the process of submitting the claim, there might be things that you need to do as a lender to protect your lien, to protect your interest, and you need to be doing those things while the claim is pending. So, for example, if you were sued, you probably have some deadlines by which you need to respond to the complaint. So you need to go out and hire an attorney, and you need to make sure that that's being handled. Similarly, if there's a senior lien that's going to foreclosure sale, you probably need to hire an attorney to go out and file an injunction or something along those lines while the claim is pending. You can't just say, oh, I submitted a claim and that's sufficient, and the title insurance company is now on the hook for handling whatever needs to be handled. That's not how it works. The title company can still raise the prejudice clause if you fail to take action or you take incorrect action to protect your lien rights.
Okay. So title company accepts a claim.
Yep.
Now what?
So there are a few different things that might happen. As we said, the least common of which is that they are going to cut the lender a check for a lost payment. The most likely outcome is that they are going to want to fix the title issue that is causing the title claim in the first place. And they will do that by filing a lawsuit or defending a lawsuit if one has been filed.
Okay. So walk through like kind of some of the issues we should expect working with the title company on a claim. I mean, it's
sure.
It sounds to me like it's a good idea to have your own attorney involved. I mean, they're gonna offer you defense, but you almost have better off also getting your attorney just to defend yourself.
Yeah, I mean, I would say it's definitely worthwhile as a lender to bring in your own counsel to work with the title insurance company. A lot of what we do, a lot of times when there's title insurance involved and a claim is accepted, our firm will stay on and we will be the point of contact for the insured, for the client, and we'll be able to monitor the title insurance litigation itself and assist with discovery, things like that. So when a lender is working with a title insurance company, there's a duty to cooperate, right? So that means you have to respond to the title attorney timely. You have to provide documents. You have to sign declarations. You have to make yourself available or staff members available to appear at depositions, things like that as needed. But beyond that, it's important to have an attorney involved because, again, the title insurance attorney is really only focused and their only obligation is on the title issues. There might be other issues going on in this case for which a lender will be very well served having an attorney. For example, prosecuting a cross complaint for judicial foreclosure, or maybe some type of damages action. Maybe this is a case of loan fraud. Maybe the borrower made some misrepresentations to the lender. The title insurance attorney is not even going to look at those, not even bring them up, not even raise them with you. In fact, their representation letter is going to say explicitly, I'm not involved in any of that stuff. So again, it's always good to have your own attorney involved in some capacity advising you on, is there anything else we can or should be doing in this lawsuit at this point to move forward with our objectives.
It brings up, from a title perspective, a couple of years back, we had an issue where our borrower, we had financed a fix and flip loan, borrower went to go sell the property, and there became a boundary dispute between the neighbor, and that held up closing. And I think I was involved for about 6 months. Borrower was stuck having to pay us, interest on this money, but we had to reach out to title company to have this resolved. I think at the end of the day, the borrower ended up paying the neighbor a certain dollar amount, and then they corrected the boundary issue. But we found that issue was more because it was a kind of a rural property, and it's something that it was a lesson learned to me. So when we get kind of rural properties that are located in more rural areas, to really understand where those boundaries are and make sure that we're going to be covered under those.
Yeah, and generally speaking, you can always request a survey be done
Yeah.
during the underwriting process. So if there's a question of boundaries, or if you feel like that's something that's important, oftentimes you can just request that the title insurance company go out and perform a survey.
Yeah, true. We talked about this yesterday. Reservation of rights. What is
Yeah.
reservation of rights?
So reservation of rights is basically the title insurance company saying, okay, we've received your title claim. We're going to go ahead and provide coverage. And typically these are issued in the context of where the lender is sued. So let's say there's a lawsuit against a lender. The title insurance companies will say, okay, we're going to defend. We're going to just assume that there's coverage here. But if anything comes up down the road, any kind of facts or evidence comes out that shows that there is not actually coverage here for whatever reason, then we're reserving our rights to pull coverage and to decline to represent you and to seek reimbursement of the attorney's fees.
Oh, interesting. So that's something that they
Yeah,
could be looking for throughout the entire litigation.
absolutely. Yeah, yeah. So the typical scenario where you see reservations of rights.
Yeah.
So I guess I should say that legally speaking, the reservation has to be based on something. They can't just reserve rights as a matter of course. So if you submit a claim and there's no basis for a reservation of rights, that's something that the insured should probably push back on. Again, that's a good example of where having your own private attorney involved in some capacity, kind of reviewing this stuff, that attorney might be able to say, hey, wait a minute, this is not, we should push back on this. But typically where you'll find that is a lawsuit that alleges claims against a lender that are not just limited to title, right? So when a lawsuit's filed, typically there's all sorts of claims that are alleged. Yeah, you might have a classic example for a lender is you might have some title issues alleged, but then you also have some foreclosure violations that are being alleged, right? Because obviously the borrower's in default and they're trying to avoid foreclosure, so they're going to attack everything that they can. So a title insurance company, and then let's say that the borrower is also alleging fraud against the lender, right? So fraud is a big one. So the title insurance company is going to say, look, there's a fraud claim against the lender. The allegation is that the lender was involved with the fraud that the borrower is alleging. We're going to reserve our rights. If that proves to be true, or there's evidence suggesting that that's true, then we're reserving our rights to deny coverage down the road. So we call those hybrid lawsuits, where part of that lawsuit would be covered by a title insurance policy and an attorney would be represented. The other part is not going to be covered. The title insurance company will tell you, sorry, we're only defending these claims here. We're not defending these other claims, in which case the lender has to go out and get their own private counsel to come in and defend those claims. And we do a lot of that as well. We will associate in and we'll work with the title insurance company, and we work on the lender side claims. The title insurance company work on the title side claims.
Okay. So, and this is another question I brought up just to confirm. So, if you have a title claim and you're going through a foreclosure, which usually those kind of are hand in hand, and that's why this title claim has come up, you can continue going through the foreclosure while you're figuring out this title issue.
Yeah. Generally speaking, yes, although you have to kind of take a look at the circumstances. So the title insurance policy, if a lender forecloses and takes the property back on REO as the high credit bidder, the title insurance policy will continue in force and effect in favor of that lender. Okay. If the property forecloses and it sells third party, the title insurance coverage, generally speaking, is going to terminate. So
okay, so
as a lender,
go ahead.
Yeah. So I was gonna say, as a lender, if you're wrapped up in litigation, if you think that the foreclosure is going to result in an REO property, then I think generally speaking, yeah, go ahead and foreclose. Obviously, you want to coordinate that with the title insurance company and just let them know. I always try to reach out to the title insurance company and say, hey, we're foreclosing. Please provide me assurances that the policy will continue in force and effect. Usually I get that. But if it sells third party, you could be in a situation where you're wrapped up in a lawsuit. You've just foreclosed on the property, you've liquidated the asset, but now, the title insurance company is saying, well, sorry.
Okay.
Yeah, that's correct. You still have a lawsuit that you need to deal with. The title company could potentially say, well, sorry, we're just not going to defend this anymore. because the loan has been basically liquidated and you no longer have an interest.
Okay. So obviously there are cases where claims get denied.
Yeah.
What options do I have?
So number one, go through the denial letter, make sure that it's correct. The denial letter will set forth the facts and the law and everything and the policy provisions it's based on. Just make sure that the title insurance company is operating on correct facts. Correct any facts that you see need to be corrected. Alternatively, you know, and if that's not an option and you think there's the claim should have been accepted, that's the point in time to, if you haven't already, get your own private attorney involved to push back on the title company, threaten them with potentially a bad faith lawsuit. And if all that fails, the options are really just to file a lawsuit for breach of contract or bad faith denial of the policy, or potentially move forward with an arbitration. The policies have arbitration provisions. So there's pros and cons to both of those. That's a discussion for the lender to have with their counsel.
Okay. Question came in here. In the private lending industry, there are a lot of assignments. Either from, I kind of shared kind of how we used to do it, where we would fund under the TaliMar name and assign different investors that note.
Yeah.
What can investors who get assigned interest, what can they do to protect themselves to ensure that they're covered under the lender, a lender title policy, and kind of what issues have you seen in the past?
Yeah. So generally speaking, double check the policy, make sure that it's got the verbiage in there, that it was issued in the name of the originating lender, or its successors and assigns. If that verbiage is in there, you're generally going to be protected as long as you can produce documentation showing that you have been assigned the interest in the loan in the deed of trust. Also, if the promissory note's been endorsed, or there's been a launch to it or anything like that, you know, do your best to just make sure you have a complete, either a note that's endorsed in blank, or you've got endorsements that track all the way back to the originating lender. That's going to be sufficient to ensure that the title insurance coverage continues and transfers on to you as the you know, present current lender. You can also get an assignment endorsement from the title insurance company, which ensures that you have the assigned interest under the loan in the deed of trust. It's not totally necessary if you just want to make sure that you have coverage under the policy. As long as the other things we talked about are present. The assignment endorsement also provides some additional coverages. It provides coverage that there's no other assignment that's been recorded in the chain of title. I think it also provides coverage that there's no reconveyance that shows in the chain of title. So the assignment endorsement is not necessary, but it does provide a little bit of extra coverage for some other things that might be important depending on the transaction.
Yeah, and I, you know, from a lender perspective, a broker's perspective, if you were investing in individual trust deeds and you're getting assignments, I would highly recommend that you get that endorsement, just because of exactly what you talked about, where there's been fraud issues with the loan's already been reconveyed, or the loan has been assigned, you know, the one loan's been assigned 10 times to different investors, and a broker is dealing with fraud at that point. So I appreciate that. So that about does it, Olivier, with the questions that I have. I really appreciate you jumping on today and kind of explaining what a lender title policy is, how lenders can protect themselves, and then how to kind of work with title companies if they have a claim. So with that, would you do me a favor? Can you share your contact information with everybody? And just keep in mind that we're also going to send out a quick email with Olivier's contact information as well, and a link to the recorded version of this webinar. So highly recommend that you reach out to Olivier and with any title related questions. I know he'd be more than happy to answer any questions for you. So Olivier, if you would share your contact info.
Yeah, I'm going to do that. I'm going to load it, my contact information to the chat. But like Brock said, you'll be receiving a separate email with that. So I'm always happy to pick up the phone or respond an email. So if you maybe have a question you weren't able to answer, feel free to reach out. Or if you just have something else going on, please feel free to pick up the phone or shoot me an email. And thank you very much, Brock, for this opportunity. I had a great time.
Yeah, Olivier, thanks again. All right, and then thank you for everybody that participated today. And definitely check out our YouTube site for any other additional from webinars that we've posted. Olivia, thanks.